All right. Hello, everyone, and welcome to another CLE here presented to you by Legal Advantage. And the CLE today that we will be covering is the best practices and being able to gain a competitive advantage through prior art. We have a lovely panel that's decided to join us for today. So please do ask your questions in the chat box for our panelists. Just to give you a little background information, my name is Amir Ahmed. I'm the senior patent analyst here. Graduated from George Mason University and spent almost 8 years after that at the patent office as a technical information specialist, which covers conducting prior art searches for the examiners when they're not able to find prior art themselves as a search specialist. I also helped teach some of the new hire patent examiners into prior art search techniques, the different databases, how to be able to conduct searches, the strategies, and so forth. Along with me is Jeff Sobek. He is our VP of Sales and Marketing. Received his BA from Illinois Wesleyan and JD from John Marshall Law School, and at this point has well over 22 years of sales experience in the technology marketplace. On to our panel that has decided to join us today. First and foremost, we have Craig Nyheisel from Dinsmore and Scholl. Received his master's in electrical engineering from the University of Michigan and his JD from Cincinnati College of Law. As well with us is Todd Sharon from Gilbride Chusa Lassen Spillane. Received his master's of molecular biology from Boston University and his JD from Benjamin Cardozo School of Law. Also with us is Mr. David Rodriguez from Cantor Colburn. Received his PhD in material engineering and science from the University of Polytechnic Institute and State University. Craig, would you like to give us just a little brief background of yourself, please?
Yeah, sure. So I'm a partner at Dinsmore. My practice focuses on primarily preparation and prosecution in the electrical and software arts. I do a fair amount of U.S. and directing foreign prosecution, and I also have a significant amount of freedom to operate type work as well as the non-infringement and invalidity opinions that accompany that. Thank
you very much, Craig. Mr. Todd Sharon, would you like to give us a little introduction to yourself, sir?
Not particularly, but I will anyway. So I'm very pleased to be included amongst the talented other members on this committee board. I hopefully won't disappoint. I've been doing this for a long time. I really enjoy working with my clients. I predominantly litigate, but I am also involved pretty heavily with running a prosecution practice and just a general counseling on freedom to use, whether or not we should be suing for litigation, cancellation, all that kind of good stuff. I'm going to pass it to Mr. Rodriguez now.
Thank you, Todd. David. All right, we'll go ahead and continue. I know David's on the line with us. For some reason, we're having a hard time hearing him. Let us continue on to what we're going to be conducting today for the CLE. In order to receive credit for attending the CLE today, we will have a verbal passphrase at some point during the presentation. Once you hear the verbal passphrase, please write down that verbal passphrase, send us an email to the email address that's on your screen, search@legaladvantage.net. With the verbal passphrase, your name and your bar number. We have applied for credit for the CLE. We have not received that at this moment. And so in the meantime, we will be giving you a certificate of attendance in the meantime until we are able to give you the credit, and then we will follow up with the credit when the time for us to be able to give that. Hello, David. How are you?
Hi, I'm doing well. Sorry, for some reason I couldn't get you through my computer. I hope it's not producing any echo. Anyway,
no, we can hear you just fine.
All right, okay. Thank you for inviting me to be on the panel. I work as a partner for Cantor Colburn at the Houston office. Most of my work focuses on chemistry and materials preparation and prosecution. Most of it is directed towards polymers and some towards optics in general. And I also do a little bit of opinion work from time to time, and that too is mostly directed in the area of polymer processing and polymer chemistry. And I've been working with Cantor Colburn for about 20 years. So it's a pleasure to be with all of the others on this panel. Thanks.
Thank you very much, David. It's a pleasure to have you. So as I was saying, we will be giving credit for the CLE. If you write down the verbal passphrase that we'll be giving at some point during the presentation, send us an email to the email address that's on your screen. We'll be giving a certificate of attendance in the meantime, and once we have the accreditation for this CLE, we'll be following up with the credit to come. So let us just jump really quickly into what we're going to be covering throughout the CLE today. And we'll start off with the basics, which are the different search types and the different strategies. We'll talk about some of the hurdles that may be encountered throughout each search type, and then we'll get into some of the databases that are available. We are not going to focus on the databases for too long, since there are well over 2,000 databases to choose from. We've selected a few that we would like to highlight, some of the free databases that are available and some of the subscription type of databases that are available and what the capabilities are of each one. Then we will get into the searching to a competitive advantage, and we'll highlight some of the advantages that are available from conducting a prior art search at different levels, whether it's in the prosecution, whether it's business intelligence, or whether it's litigation. And there are different stages within each one where you can conduct a search to have an advantage over the competition, and just having the knowledge in compared to the competition, whether that's the examiner or whether that's and someone else in the field or another IP entity in the field. So let's get right into the search types and the strategies. And in a very general sense, searches will tend to fall into three major categories, whether they're prosecution searches, business intelligence, or litigation. But why would you conduct a search in the first place? Well, first and foremost, of course, you would like to learn more about the field of the invention, before you draft the claims of an application, to understand how the drafting of the claims can be done, what the patent office may encounter in terms of their prior art search and come back with rejection, whether it's focusing the drafted claims after a rejection has received or an amendment has been received, understanding the competition, knowing what's out there, whether you're looking to enter a field, whether you're looking to acquire a company and understanding the IP portfolio, whether you're seeing where the white space is and being able to put together your claims or operate within a certain field, understanding where you're free of infringement. And so there are many different stages where a prior art search can be extremely helpful in navigating the IP field. So as mentioned, the prosecution searches, which will fall into the novelty patentability type of searches, accelerated examination. And then we have our competitive business intelligence. And that's usually the patent watch, where you're seeing what's being filed into a certain field, any change of status, any new players in the market, and so on. Landscape analysis is a much more broad type of search, throwing a big net out there, conducting a lot of post-search analysis to be able to determine what these results actually mean. And then finally, the litigation or go-to-market or market analysis type of searches, and those are the state-of-the-art, freedom to operate, infringement, and then your validity and invalidity. So we're going to hit on every single type of these searches very briefly, and then we'll get into our databases. And so, of course, with regards to the prosecution type of search, we're going to focus on the patentability search. And in this case, of course, the patentability search is meant to show you what art is out there, either from a single reference or multiple reference, that can affect the claims that are to be drafted. The search is conducted in all available resources, U.S. patents, foreign patents, non-patent literature. And again, the idea there is to look for a single reference or multiple references that can be combined together in obviousness that can have an effect on the claims that are to be drafted, or whether you're amending claims. Moving on to the litigation type of searches, and in this case, the validity and invalidity type of search. Similar to the patentability search, however, it is a lot more robust in terms of being able to capture art that's out there. What you're looking to do is invalidate a claim that has already been granted. And with that being said, we're looking at all available resources, patents in the U.S. database, foreign patents, non-patent literature. Again, we're looking for a single reference or multiple reference that can be put together in obviousness to be able to affect the validity of the claim. Now, there is one thing that is essential here when we're conducting a validity and invalidity search, is the fact that any reference, in order to be valid or a viable reference for us to use, has to be available before the priority date of the patent that is being invalidated. And so the strategy here when it comes to conducting an invalidity is to determine first and foremost which claims need to be targeted and invalidated. Retrieving a file history which will give you what this patent went through from the moment it was filed to the moment it was granted, what the patent office has done with it, and what back and forth has happened. It gives you an idea of what may be missing in there. Performing these forward and backward citations, and then from there being able to construct this validity matrix. And we'll give an example of that later on in the presentation. Now, the approach for the validity and invalidity type of searches is either to have a conservative approach of staying focused on invalidating a claim at a time, or the more liberal approach of conducting concepts, searching concepts, capturing many results, and then sending those results off to litigation teams for them to be able to determine the relevancy of the results. And then finally, the landscape analysis type of searches. And these are the competitive business intelligence type of searches. And these are usually done with a very, very large net thrown out there, capturing many, many results. And it can be tailored to find whether a patent or a patent family and related patents in that field, or even searching a patent portfolio and seeing what patents they have, who the players are in the field, who are their competition, or even in a much larger scale, a technology or a sector. And from that being said, now hundreds of hours, at least 50, 60 hours of search go into these landscape analyses to determine the relevancy of these results. And so we have put together a example for you here, the landscape analysis that I'll be getting into in the next couple slides. But of course, a lot of post-search analysis, and then the post-search analysis will be able to determine whether that particular technology or marketplace is showing stagnancy, or if there's saturation, or if there's potential for growth. A lot of post-search analysis done for these landscape analyses. And so here's one that we put together for the purpose of this presentation, and it is related to antiviral drugs, which are of high importance nowadays. Well, antiviral drugs, that's a very broad spectrum. If we look at antiviral drugs, we'll see that China holds by easily the majority of the antiviral drugs that are filed for IP, more specifically Shanghai Board gene development as one of them. And so if we take those same sets of results, of course, looking at them by jurisdiction, we can easily see that China is the one who holds the most of this IP or IP filing. Well, it begs the question, why? And then we look at the patent filing growth, and we'll see that in 2001, they had extreme growth in their filings. Well, what happened in 2001? They were brought into the World Trade Organization. And from that point, all of the genetic studies that they were doing, they were filing patents for every genetic sequence that they were finding. Now, mind you, most of those were rejected, but still, it skews the numbers to show that they hold a lot of this IP, when in fact, looking a little bit closer, we're able to break down the results into which ones actually have to do with coronavirus. And in this case, coronavirus is just the name of the type of virus and the shape of what it looks like, the corona being the crown. And that can be broken down into multiple different types of coronavirus, including SARS, MERS. There are multiple coronaviruses that are out there. And then, of course, we have the novel coronavirus that we have today. And so from those filings, you'll be able to see a spike in 2019 with that coronavirus. There is a spike in 2003, and that has to do with the SARS outbreak. And so that brings a different perspective. It puts a different, it shines a different light on the same set of results to show a different scenario. And so when we look at the coronavirus filings in particular, it shows us that the U.S. by far has the highest number of IP, being led by the United States Health and Human Services, followed by Johnson & Johnson. And then some of these other companies that I'm sure you've seen in the news very recently with some of the drugs that they're working on with regards to the trials in coronavirus. And so the same sets of results there from that landscape of throwing a large net out and then doing a post-search analysis to give a very different story of what is really happening out there. And so that shows the different types of the different filings, and then the clinical trials that are being done with the actual drugs that have been mentioned. So we've put together a checklist here with regards to being able to conduct a search and keep the search headed in the right direction from start to finish. And of course, first and foremost, determining the type of search that needs to be conducted, followed by what are the elements that the search is going after? What are the claims that are invalidated, or what are the aspects of novelty that we're looking for? Determining if there's a limitation in terms of date, and then being able to select the databases that are most helpful for this search. From that point, being able to locate all the terms that are relevant and all the classification codes that are relevant is extremely helpful. Conducting a search using only classification codes is a way to conduct a search, and also conducting a search using only key terms is another way to conduct a search. And then, of course, there's that third iteration of being able to conduct a search using classification codes and key terms in combination, and that usually gives you the best sets of results. Of course, it's a good practice to conduct a search in all three iterations and look at those search results as a collective. Now, Mr. Rodriguez, I believe you mentioned that you help some of your attorneys with guiding them, some of the companies with guiding them through their IP portfolios. What do you believe is the most helpful in terms of being able to conduct a search? Do you often conduct landscape analyses to be able to really give them the guidance in terms of what IP is there and what they need to be careful of?
Yes, we do. Most of the searches that I've undertaken on behalf of clients are patentability searches done before they file an application. And these searches are useful. The most important thing I would say is selecting the proper keywords. And oftentimes I find that the keywords provided to us by the inventors and by the company are not adequate, and better keywords sometimes are derived. Once you start the search, you begin to realize what keywords produce the best results, okay? And the net effect of doing it, my observation has been that when you do a patentability search, then draft the application based on that search, you end up saving a lot of money on the prosecution end of things, because you typically find the best art, it's provided to the examiner, and you draft claims, of course, that avoid that art. And as a result of it, I've noticed at least that whenever we've done those searches, or whenever the in-house counsel for the particular company has done searches, prosecution tends to end much more quickly, resulting in a saving of money for them.
Yes, absolutely. That makes a lot of sense. You have a lot less back and forth, and you're submitting to them what you already know and what may stand in the way, and drafting in accordance to that.
Right.
That makes a lot of sense. All right, let us continue.
The drawback of the drawback, of course, is that companies sometimes have quotas to fill in terms of patents, right? So the inventors submit a list of different patentable inventions to their in-house counsel, and oftentimes when the search is conducted, the in-house counsel discovers that a lot of the ideas are not patentable because there is existing art, and so consequently they're now struggling to spend their IP money before the end of the year or in a given quarter or something like that. So that's one of the it's a good problem to have, but it's the drawback of doing a patent search, I suppose.
Yes, agreed. Definitely agreed. Yeah, and Craig, if you'd like to give us some of your input here, I know you also help guide some of these corporations and companies in terms of their IP portfolios. I believe that you're pretty familiar with landscape analysis, and how does it help you give them the guidance in the field?
Yeah, it's a great question, Amir. So yeah, I do a fair amount of landscape analysis. So for instance, if a client is thinking about bringing some feature to market or some even area of technology to market, there might be a couple different ways that they can go about, implementing or realizing what it is they're planning to do. So we'll initiate a landscape search for you guys to try to identify, like, hey, here's broad strokes, what we're looking at, what we're looking for in this technology area. We'll get those search results, and then we'll typically, categorize them or put them in sort of like buckets or areas to determine, like, okay, if we want to do this broad, general saying, we can do it in 3 or 4 different manners. It looks like there's a lot of prior art in 2 or 3 of those areas, and then there might be some white space in one of the fourth areas. You can understand what the landscape looks like in terms of technology, who the players are, what business relationships your client has with those players, to then determine like what the appropriate way to kind of proceed is. So maybe it's like, wow, this is a really crowded space. There's a lot of risk here. We shouldn't go for it at all. Or it could be that, yeah, we clearly want to go, take path A and the fork in the road instead of path B, because it's a lot cleaner. So it helps to guide investment decisions of how do we want to spend money to avoid those potential pitfalls downstream. I think it's one really good use for landscape analyses.
Thank you very much for the insights, Greg. Let us continue really quickly on to the next section here, which is the search strategies. And in this case, we're going to be focusing more on what are the hurdles when preparing for a search. Finding key terms, of course, as Mr. David mentioned. How do you overcome finding these terms that are relevant for the search? And he mentioned, actually, while you're conducting the search, you do come along some really, really good terms that can be used or incorporated into the search strategy, which is always a good, of course, way to accrue or be able to gain more and more terms that are relevant for the search. But of course, we do know that appropriate terms are unknown a lot of times when you're starting to get into a search. Certain terms have multiple meanings or can be used in multiple contexts, or innovation can change how a term is used. And then there are the language barriers, of course, and that is referring more towards foreign translated text, whether it's machine translated or human translated. A lot of times you will see that the construction of the sentences and the construction of the verbiage is very different than would be in natural English. And so the strategy needs to be adjusted for that as well. So how do you overcome these issues? Preliminary research, of course, as David mentioned, being able to look at other patents and other resources that will be able to give you those terms that are relevant for the purpose of the search. Searching in database, technology-specific databases are extremely helpful, specifically those that are written for the experts by the experts. And you tend to pick up some really, really good terminology there. And then, of course, also looking at some of the other terms like the marketed names, the internal names, the scientific names. Very, very helpful to incorporate those into the strategy. You cannot have enough key terms to capture a concept in the search strategy. And then, of course, also incorporating these abbreviations, putting in these Marcouche truncations to be able to capture terms that end a certain way or start a certain way, be able to capture everything that's out there, even if they're spelled differently. And so here's a quick example of a term that can actually bring in a lot of noise. And in this case, just being able to capture terms that are related to anti-replication drugs for COVID-19. And so in this case, in particular, we're looking at COVID-19 and how do we actually find terms that are relevant to COVID-19. If you take a couple seconds and just think of the terms that you would use to search for COVID-19 in the databases, you'll probably come up with some really good ones. But if you do just a little bit of research and incorporate terms that are relevant, you'll be able to come up with a laundry list of terms. And I'm sure you can see terms that you've heard in the news as the drugs that have been used as studies for it. And sometimes, as in some articles, they will mention only the drug and not what it's curing. They will mention the drug and what it's being studied to help. And so that's also a good idea, is to incorporate any of the terms that may be even relevant. If it's not exactly spot on, it's close enough to where if you do capture art that doesn't necessarily mention the disease itself, it'll mention what is being used or attempted to try to remedy it. And that also helps capture art that's out there that may not be obviously found in the art. And so, of course, the other part is when you're conducting a search and you've used these terms that have multiple meanings or used in multiple contexts, you'll see that, of course, they're bringing in results that are too many results or a poor quality of results, and those usually go hand in hand. It's not a good idea to eliminate those terms completely. There's a reason why you put them into your search strategy. Do not take them out. Bring them into focus with something that will do that for you, whether it's linking them to classification codes or linking those terms to other sets of terms that you've put together that are not essential for the search, but can help in narrowing down the scope to bring it into focus. And so that's the context matters example here, a term that can bring in a lot of noise. And again, we're going to talk about one that's very relevant for our days today. And that one has to do with spike protein, which of course, a lot of studies is being conducted regarding the spike protein. Some of the terms that you can come up with, of course, for spike protein, spike host cell receptor, and the other terms that refer to spike protein. But if you put spike and protein into a database, you're going to get results from all over the place because the term spike on its own will capture a lot of hits that are not relevant. The term spike can be used as a spit, or athletic shoes have spikes, or a stake, or horns. And so how do you bring that into focus? You take that spike and you link it to these classification codes. And in that sense, you're telling the database that when this term shows up, make sure that this classification code is somewhere in that document. And that way it brings it into focus. Because I really doubt that athletic shoes will have anything to do with viral vectors. And so that's how you bring that term into focus. Now, we've mentioned classification codes multiple times. Just want to cover them with you fairly quickly with regards to the cooperative patent classifications. And they're put together by the European Patent Office and the US Patent Office. They're based on the international patent classifications, which were being used before. And both entities incorporated these by December of 2014, and they've even gone back in time and linked these CPC codes to older patents as well. Very straightforward navigation through their website. You can either use the search box to search for the particular classification that you're looking for by looking for it by name, or you can go through the A through H sections and click on any section that is relevant, and that section is broken down into classes and broken down into subclasses, main group and subgroup. So that's how you navigate through the CPC classifications and incorporating them. They're essential, as essential as keywords. So we've reached the section about the databases that I mentioned. We're going to take a little bit of time on here. We're going to be looking at some of the free databases, some of the subscription databases. And then, of course, we're going to be looking at the different pros and cons for them. Now, in regards to the resources that are available, there are multiple resources that are available, and you'll see that some of these databases are able to conduct both patent and non-patent literature. I know David, as someone who's searching for polymers, for example, STM is probably a database that you're very, very familiar with. You can search patents and non-patents on there at the same time. So very many resources that are out there. We're just going to look at a couple of them. In this case, the free databases we're looking at are PatentScope, eSpaceNet, Free Patents Online, and Google Patents. You can see that they have full coverage of the US patents. They have full coverage of the Japanese. Free Patents Online is sometimes iffy when it comes to the European and PCT. However, a lot of them do have machine translations. They're updated weekly, and PatentScope and eSpaceNet will give you the InfoDoc family coverage, which Free Patents Online and Google Patents will not. With regards to their search engines, they're all able to do the forward and backward citations. They, for the most part, will have the IPC classes listed. eSpaceNet does not have the US classes listed. And as great as the coverage that eSpaceNet has, it does lack in the search engine with regards to the proximity operators, truncation, keyword highlighting, and user-defined highlighting. Now, with regards to the interface and what you're able to do with your actual sets of results, none of them will allow you to export your searches or import your list of references. So it's a good idea to go into these databases and do your preliminary research where you're gaining some background information, seeing what obvious patents are out there, and maybe even capturing some key terms that you can use in your strategy. Conducting a thorough search in one of those resources is very, very difficult. So that brings us to the next section, which is the subscription type of databases. And in this case, we're looking at Patsier, Orbit, Derwent Innovation, and Relectua. And as you can see, check marks all across the board, full coverage of the US, the European, the Japanese jurisdictions, machine translations available, they're updated weekly, and InfoDoc family coverage for all of them. With regards to their search engines, of course, all of them have full capabilities of being able to conduct the forward and backward citations. US, international, and cooperative patent classifications are listed and searchable. Boolean operators, proximity operators, truncation is supported on their search engines as well. So very powerful searching tools. With regards to their results there, you're able to save your queries and export your searches, import your list of references, export document data, and even download individual patents. Now, Todd, I know that you're pretty familiar with being able to conduct searches. Are there any databases that you have in particular that you like to, as your go-to when you're doing your background information gathering?
Typically, I would prefer to let the engineers and the scientists that made the invention in the first place kind of guide me through the technology. I'll do some general searches on some of the sites that you referenced, but to be completely frank, I like to streamline this. And once I have some idea of what's going on, I like to turn it over to you guys so that I can get a better sense of what's out there. Usually we start with, either a patentability or a landscape analysis, depending upon where we are in the process. But generally speaking, I don't do a lot of my own searching. I don't find it to be a useful tool at my rate for my clients. I do have paralegals that occasionally do it when we need them to.
Completely understood. Yeah, that makes a lot of sense, of course. Let the experts give you their background and bring you up to speed with that for sure.
Yes, but also, besides the experts, you guys have been very good to us. So when we're able to provide you with the right starting points, it doesn't always happen in one search. Sometimes there's 2 or 3 searches till we finally get to what we're looking for in the first place, with a little bit of sometimes trial and error, but most of the time it's just educating both ourselves, our client, and our searching crew, which is in most cases you guys.
Thank you very much, Todd. Thank you for the insight. All right, so we've reached the verbal passphrase section of our presentation today. So please write down the verbal passphrase, send us an email with your name and your bar number and the verbal passphrase in order to receive a certificate of attendance, and then we will follow up with a CLE credits once they're issued. The verbal passphrase for today is it's a windy day in Washington, D.C. That is the verbal passphrase for today. It's a windy day in Washington, D.C. I'll give you a second to write that down, and then we'll continue to our competitive advantage from prior art search. All right, let us continue here to searching to a competitive advantage. And we'll look at 3 different main points where you can gain a pretty good advantage there with regards to conducting a prior art search, to be able to know what's out there and what can stand in your way and what obstacles may be faced. And so let's get right into the prosecution and the conducting a prior art search at the prosecution stage. Of course, we mentioned at the earlier part of this presentation, if you're going to be drafting claims before you've filed for a patent, it helps you understand what's out there, focusing the claims, anticipating the examiner rejections. So if you have an idea of what art is already out there and you're filing for a patent, you can already game plan your next move by anticipating what the examiner is going to see. If you're doing it after the filing, of course, understanding what needs to be done to the claims in order for them to be amended, understanding the other applications or patents that are in the field, and then that will help you amend the claims that are going to be sent to the patent office. So, of course, an example here of a patent that can come back with some amended claims that are added to it before it is issued. And so with regards to a patentability search report, you'll be able to see fairly quickly the art that came back as a positive hit on either a single reference as mentioned or multiple references together that can have an effect on the novelty of that application. Would any one of you, our panelists, like to give us any advantages that you've seen with conducting a prior art search in the prosecution field? Mr. David, would you like to give us a little more information of how it helps you in particular?
Amir, if you'd like, I'd be happy to comment.
Please do.
Okay. So while David collects his thoughts, this is Todd. What I've found mostly is this really, just like I said, it's like a guided journey, for lack of a better term. You know, I also, I'm sorry, just do me a favor, just repeat the question one more time, because I for some reason lost my train of thought.
Sure. Other than what we've just mentioned, what we've covered in terms of why you would conduct a search while you're in prosecution, whether you're before you're filing to focus the claims, or even after an office action to be able to amend the claims. Are there any other times where you would conduct a search in the prosecution phase that you find are helpful to you?
We've used them sometimes besides what you've referenced. I mean, those are obviously the two most common applications, but we've used them for appeals and for responses after final, where we just feel like we're out of ideas and we're trying to find a way through this, navigate through the maze itself. I'm not sure if that's what you were hoping for or looking for.
Yeah, of course. Yeah, that's very helpful. Very helpful.
Okay.
That's another, of course, very helpful stage to be able to conduct a prior search, for sure. Thank you, Todd.
Amir, this
Yes, sir.
is David. Can you hear me? Yeah, so sorry, my phone was on mute. That's why I couldn't. I started talking, but then realized that you couldn't hear me. And thanks, Todd, for jumping in. Anyway, one of the times I've conducted a search during prosecution is when I know that the examiner has said something that's wrong. You know, like let's say he's combined A and B in the field of polymers. He's combined two materials together, and he goes, the motivation for doing this would be to improve impact properties of the resulting composite. And I know that that's not what happens. I know from my background and from testing samples of this kind that that is not what happens. At that point, there are two approaches one can take. One can either get the inventor to do experimentation to disprove the examiner. The other thing would be to look up a reference, either a textbook reference or a patent, and send that into the examiner with an IDS pointing out to him where he's wrong. Getting the inventor to do experimental work is not always easy. Sometimes they've moved on from the project that you drafted the application on, and now they have something more important to do. So that's not an easy avenue to pursue. It therefore becomes imperative, especially because the company still wants to get a patent, even though the inventor's moved on, to actually look up for a reference that cites, that specifically points out to the examiner that he's wrong and sending it to him. So that's one of the times I've done a search. I've even done those searches during an appeal, in the middle of an appeal, and sent the reference as part of an appendix to the examiner. Now, or to the PTAB. Now, it depends. If the examiner decides not to allow it in at that stage, it's dead in the water. But sometimes the examiners, I don't know, for whatever reason, have been gracious enough to allow that reference to get into the prosecution, even though it was not cited prior to the appeal. And I know that I won at least a couple of cases that way, So that's typically when I've done a search in the middle of prosecution. One other time I know that I've done searches in the middle of prosecution was when I was in an accelerated examination with the examiner. I'd given him all the out that was necessary, and he came up again with a reason to tell us that we were not, we couldn't get a patent, and I cited something to him that he eventually accepted and allowed the case to, allowed the case to go through to allowance. So, yeah, those are the two times I've done it in the past.
Very, very interesting scenarios. Thank you, David. So we're going to continue here with our competitive business intelligence. And at this point, this is usually conducted post-grant. You're really looking at business intelligence there. This covers the freedom to operate, the landscape analyses, and really understanding any filings or any changes to a specific field. Whether you're conducting a search to see who the new players are in the field, any change of status for any applications turning into issued patents, or even updating a company portfolio, understanding what IP they hold, filings versus grants. The landscape analysis, of course, will help you in understanding the market, the players in the market, the strength of their portfolios, their filings over time, the jurisdictions where they hold this IP, claim coverage, what their IP actually claims. And then, of course, the specialists within the organizations, you can go in there and actually see who are being assigned the inventor or assignee information there from the patents as well. Full company analysis, jurisdiction analysis, understanding certain jurisdictions and understanding where that space is available in the jurisdictions, or even claim language analysis for this competitive business intelligence. And so, of course, again, very, very large type of search that is conducted to really capture what's out there. And in this case, we took the first example where we did the antiviral drugs in general, not the coronavirus drugs, and really trying to get understanding of how many of those are out there. And you'll be able to see fairly quickly the major players in the field and the number of claims that they have, which reflect those particular antiviral drugs. And so a very broad type of search that will be able to compile a lot of these results side by side and show you a very side-by-side comparison of the IP holdings. Craig, would you like to give us some insight maybe into the advantage that you've seen with conducting these searches, specifically the landscapes and the competitive business intelligence realm?
Yeah, I think I touched on this earlier when I was describing the kind of benefits of landscape searches. I mean, I think that in addition to what I said before, to help guide business decisions, understand what areas are hot, to help navigate and determine path forward for different technology areas. I think one thing that Warren's mentioning here, and I think this is a great example that you have on the screen, is the type of visual, summaries and presentation of this information is extremely important, especially when you're communicating with inventors and business people, right? So it kind of it paints that picture, and there's a number of different types of graphics that we put together and used depending on what the concept is. And one thing that's relevant to these types of landscape studies is sort of like the keyword search. You don't know exactly how things are going to group, what the categories of references are going to look like on the front end. So sometimes what we do for these searches is we'll do kind of an initial look, some type of a rough request for a preliminary search to just get an idea of what the lay of the land is. And then we'll work closely with you and the search team to then refine and say, okay, we took a look at that. Looks like there's going to be these general themes or areas. And then as you guys do your revised and updated searching, then you can take that information into account and then help us to do some of that categorization and identification of areas that the search results might fall. So it's kind of an iterative process. And I think just with any type of searching, it's very important to establish, the scope. And I think I really like when we initiate searches where we have kind of a discussion on the front end to make sure that we understand what the expectations are in the search and everyone's on the same page. So those are a couple of thoughts on this topic.
Thank you very much, Craig. Extremely helpful for sure.
Right,
and then
I can add.
Go ahead, David.
Hello.
Yes, go ahead.
So I can add one real world situation to doing a landscape search in the middle of a project. This is 30 years old now, so I can talk about it. General Electric were trying to make electrically conducting exterior body panels for automobiles. And this is at the time when people were conscious about the weight of the automobile. So they realized that if they could make the outside of the car out of plastic instead of metal, it would reduce the weight of the car. You could get a few extra miles per gallon. But the problem was we had a competitor who had filed a tremendous number of patents in that area. This competitor was also the supplier of the raw materials for the exterior body panels. And so we did a landscape search with a law firm, and I don't think Legal Advantage existed at the time I would have come to you, but we were able to show a few pathways where we could get around this particular competitor's patents. All right, they were tenuous pathways at best, but what we did was filed a bunch of patents, using these pathways, and then during price negotiations, because these people thought that they were the only supplier and that nobody could get around their art, we were able to actually show them some of our filings, in confidentiality, and managed at least to get them to knock the price per pound of this material down. So landscape searches, even in the middle of a project, when you have a competitor, not a bad thing if they point you to a way out of your problem, and that's what happened in that particular case.
Yeah, that's a very, very interesting use. Very interesting. Thank you, David. All right, and we're on to our last really major section here of being able to conduct a prior art search to gain a competitive advantage, and that's in litigation-related matters. Infringement, of course, being able to locate where the infringing parties are of your issued patent, and then verifying these license agreements are being honored, that if you're licensing your patent out to if you have an agreement with a different company, making sure that they're following the guidelines. When it comes to the validity type of search, of course, ensuring that the claims of your issued patent are not covered in any previous patents, ensuring the strength of the patent of the acquisition, foreseeing any competitive attempts for invalidation. So, of course, being able to do a validity search to make sure that this patent actually is a valid patent and very strong versus invalidity in the future. And then on the other side of that coin, the invalidity search will help you to see the other patent claims which hold precedence over the claims of this patent that is an acquisition, or locate prior art in the form of a patent or non-patent literature, which can describe the novelty of the claims in the patent. So this will help in the maneuvering of the marketplace to make sure that the patent itself can be invalidated, and that way you're pretty sure that you can operate within that framework. Clearance and freedom to operate searches, of course, help you in gaining the understanding of the IP marketplace, foreseeing any infringement elements, or requesting permission from the patent owner to operate within that or licensing agreements, and then understanding where there is a lack of IP, whether that requires filing for IP or being able to operate safely within that marketplace. And then finally, of course, the litigation search, which regards to the collection, is to be able to gain a collection of results. And this is like a landscape light, being able to really throw a big net out there and understanding the IP and just the marketplace there and the IP holdings and the jurisdictions. It gives you multiple technologies or jurisdictions simultaneously, so you're able to see them all together. And then being able to understand from there the multiple collections searches simultaneously or periodically after one another will help in understanding the change in the filing to issue or the patents over to multiple collections. So that's in the litigation type of space. Now, Todd, would you like to give us any insights there in regards to litigation? Have you found any other ways that you can use these searches or being able to navigate within the IP realm through these searches that can give you an advantage?
I think you pretty much covered it, soup to nuts. But generally speaking, we start with determination first and foremost. Are we looking to invalidate someone else or to make sure ours is valid before we're even moving forward? I mean, it's really part of reason and logic. A lot of times we'll use the searches after the case has actually been brought to better educate ourselves with some expert witnesses and to see what they know, what they don't know, how much prior work they've done in preparing themselves. And other than that, I think you covered it pretty soundly.
Thank you, Todd. Craig, would you like to give us any input?
Yeah, I think on this one, I don't really have anything specific to add beyond what you guys have covered. I think you did a pretty nice job.
Thank you. Mr. David?
Yes. So the only time I don't deal with litigation all that much, but the only time I know that it's been done, at least to us by another party, was to the client we were representing accused somebody of infringing their patent. They did a search and then instituted an IPR against us. And the patent application, they settled in court, okay, over the patent, but the IPR process went on because the government has a vested interest in it at that point. And the patent got invalidated and we never recovered from that. Fortunately, they had settled before the results of the IPR came out. So I suppose in such cases, doing a search and maybe if you find something relevant, instituting an IPR if you're within the time frame that IPRs are allowed could be useful.
Thank you very much, David, for your insight. All right, so let us continue. Of course, in validity report, we'll be able to show you the claims that are targeted versus the matching resultant from the search. So side-by-side comparison of the claim language. So again, it'll show you all the matters of the concepts that were searched versus the results that were actually captured. And we're going to look at a search report really quickly after this. This is the last section, and we have about 9 minutes to go. Did want to get some questions into the panel before we end this. So I'll get through this section fairly quickly with regards to best practices and components of a search report and the standard reports. And so, of course, what are the key components of a search report? The search report needs to make the attorney's life easier. The idea here is to save the effort and time that the search was conducted in order to help get the best use of the attorney's time, highlighting all the relevant information, providing all the information in organized tables and in order of relevancy, including all publication information, and also providing drawings when applicable to be able to show why that result was actually captured as a relevant piece of art. Providing all the elements that were searched and also the summary of the prior art that was uncovered throughout the search, providing along with that the set of key terms and the classification codes. So let's take a quick look here at a sample report that our team has put together. And you can see fairly quickly the type of search that was conducted, patentability search, for the following invention. The search includes the following aspects, and immediately you can see these are the major aspects that were considered essential for this search, followed by a quick summary of what was uncovered in the art. 10 patent references, 2 non-patent literature references. And so immediately gives you all the information that you need up front, letting you know what was being looked for and what was found. Followed by the search details, giving you the date that the search was conducted, any date restrictions, followed by all of the databases that were incorporated for the search, both the patent databases and the non-patent databases, followed by the concepts. So these are the major concepts. These were key terms that were being searched for the purpose of this report. Following the components of the details of the search is a table of references, giving you the results from the most relevant to the least relevant. And immediately in the table, it'll give you the publication information related to the patent number, the title, publication numbers, assignee information, and inventor information as well. Now, following the table is a breakdown of each result, giving you the publication information followed by an excerpt from that result with bolded text to bring your attention to that section and show you this is why this result was deemed relevant. Now, following the patent results are the non-patent results, and again, providing all publication information with the URL to be able to link out and go to see the actual document. Also the author information, and again, an excerpt of the text with bolded italicized text to really bring your attention to that section and show you this is exactly why this result was deemed relevant. And so that is the standard search report. And now when it comes to requesting a report, of course, providing as much information will help the search be as fruitful as possible. Providing any illustrations or drawings can be very, very helpful in driving home what the aspects of interest are. Also providing any possible prior art and what that prior art is missing. Point of novelty, making sure that is completely understood. Any priority dates or jurisdictions. And then also specify a due date of when the report is due. And so we've put together just a short couple of points here of what the benefits are of hiring a search vendor, but I'd like to turn it over actually to the panel and just have your input in terms of what benefits you've seen from having a search done in-house versus maybe hiring a vendor, and maybe comparison of those results or comparison of how thorough those searches are. David, would you like to give us some of your insights regarding that?
Yes, Amir, thank you. One of the advantages of hiring a search vendor is that it ends up costing a lot less than doing it in-house. Legal Advantage is relatively inexpensive, and I've been using you for quite some time now. The searches have been very good. Of course, sometimes we might need to go through a couple of rounds with the vendor, to end up getting the best search. But I think the biggest advantage is that at our bill rates, it becomes cost prohibitive to do a search. The second big disadvantage we have is that we don't have access to all the databases that you do. And so that in and of itself causes another problem. Lastly, I would say one of the benefits of hiring you to do the search is that you give us a fixed price up front. And then so if you want to do that second or third search, and we get back to you with a bunch of keywords, the searching becomes more efficient, but the price again is kept constant. So that in my opinion is the big advantage of using Legal Advantage or using a search vendor in general. Now, all search vendors are not created equally, because you all seem to do a good job, but some of the others from overseas are not all that good. And I think that reflects the level of technical excellence or expertise in this country versus overseas. I don't know if Todd and Greg have other thoughts on using American vendors versus overseas vendors, but it would be nice if you could address it if you do have some experience in that area.
Craig, would you like to give us your insights maybe?
Sure. Yeah. I mean, I think from our perspective, just like what the clients are looking for from us and what we're looking for from search vendors is that value, right? So then we can receive good value for the search you provide and pass along that value to our clients. So having the team that has the technical background, intimate familiarity with the technical area, in addition to the databases, it's just not efficient for, firms to have that type. Like, we can't have the level of sophistication and experience that you guys have as searchers. So I think that's where the value really comes in. We have access to your knowledge, to the tools that you have, to the volume of work that you do to get just a really high quality work product delivered to us that then we can efficiently review. And as you said, the reports are structured very nicely so that we're able to kind of take that and then, review, analyze, repackage that into what we need to deliver to our clients in an efficient manner. So I think that's my thought.
Thank you very much, Craig. Todd, do you have any insights you'd like to give us?
I kind of feel as though David and Craig pretty much handled it all. I mean, we look at Legal Advantage as a part of our team, and we respect the fact that this is what you do. And it's the old saying, do something, do it well, and you guys do. So it would be foolish at our billable rates. I think I mentioned this earlier in the presentation, that at our rates, even using associates who have no clue what they're looking for, or a paralegal, it's kind of asking people who don't have the experience, don't have the knowledge, to go and blindly search, where you all can get it down. And even if it's a few iterations till we finally get what we're looking for, it's always much less expensive that way for the client. And what you present to us is very presentable to our client without very much work at all, other than to explain, what we're seeing as a result of your search results.
Thank you very much for your insights, Todd. And so we've reached our final section now. Yes, David, go ahead.
Yeah, quickly, I have two questions for you. One is, I noticed from the results you presented just now during this presentation, most of them are patent searches of patents. What about the other art from SciFinder and all that? Do you all exhaustively search that? And the second question is, I noticed that the patent office in the field of chemistry is now coming up with more non-patent literature in their rejections. Can you speak to that? Do you have any inside information about what's changed in the patent office?
I can speak to the first aspect, which you mentioned. Yes, the non-patent literature is exhaustively searched as well. Just so happens that in the reports that we showed, we had a lot of patent references. We do spend quite a bit of time, almost as much time in the non-patent literature as we do in the patent literature, depending on where the results are coming from. With regards to the changes in the patent office, from my understanding from when I was working there, the examiners that are in 1600, 1700, which are usually the biotech and polymers and chemistry related, are usually PhDs and they're examiners that have been there for quite a while. My understanding is the reason why we're seeing more NPL here is that's where publications are coming from, rather than filing. I think there's maybe has been a change in terms of publication before filing, which I don't know if that makes any sense from protecting IP perspective, but that would be my reasoning behind it.
Okay. I was just wondering whether the patent office had granted them access to new databases or something like that, whether that might have been the drawback.
The patent office always gave full access to all of the tools to all of their examiners. And I remember being there and testing SciFinder when it first was getting started and testing it in order to deploy it to the examining core. They give access to all of their examiners. Now, when it comes to the mechanical engineering and those other sections or technologies in the patent office, maybe not all of the databases, but definitely for the specialists in terms of the 1600, 1700, they have a lot more access in terms of the databases that they have access to.
Okay. I just noticed that there are a lot more PhD dissertations being cited all of a sudden against some of the cases I'm prosecuting.
It's very interesting. Yeah, I'll look into that. And see why it's happening. I'm sure there's a reason.
I appreciate it.
I'll follow up. Yeah. All right, we're on to our last section. I think we've covered extensively question 1 and question 2. So I'll get right into question 3. I think, Todd, you might have some really good insight for us here. If you could make any changes to the patent laws, what would you implement and why?
Wow, that's a great question. Well, I'd love to put, hindsight reconstruction back into the arguments. I'm just an old guy here just trying to survive in this field. I haven't really given any thought, I'm sorry, to what patent laws I would change and how I might implement them. I'd like to see patent litigation become a little more user-friendly, and I would love to see juries that are picked in those types of cases to be picked from a different pool than typical jurors. Right now it's a popularity contest, which is fine by me on one level. I generally relate well to juries, and so do my experts, which is why I pick them. But it's no fun trying to prove a very technical issue to a group of people who, barely understand how to use a stapler. That's kind of the difficulty there. I'm sorry, I really am at a loss on this one, but I appreciate you asking me.
That's okay. No problem. David, do you have any insight for us? Anything that you'd like to see differently?
Yeah, I thought about this almost early on when I became a patent attorney, so it was almost 20 years ago, and I told it to another very good patent agent who still works for my law firm, and he said he didn't think it was a good idea, but I'm going to set it forth anyway. In the area of materials and chemistry, you always end up with a composition, right? You usually a composition or a method of making the composition. At least as far as the compositions were concerned, I thought that the patent office should specify that everybody who submits a patent application have a certain number of tests done for their materials at using a certain number of standards. So for example, if you were coming up with conductive plastics, you would have to submit to the patent office the conductivity, the amount of conductivity on a certain specimen of a certain size tested a certain way, and maybe tensile strength, again, tested a certain way, and maybe impact strength, and maybe something else. So 5 or 6 tests. So patent attorneys wouldn't have this problem later of, you have a conductive patent or conductive plastic out there. I have one, but I can't do the test you did because I just don't have the equipment to do it. And now the patent office cites that against us, and the inventor doesn't have the equipment to do the test. And so all of a sudden the patent gets lost, If everybody had to do, say, 7 different tests, and those tests could change for different areas of chemistry and materials, then there'd be an apples to apples comparison in the patent applications themselves, and would cut down on a lot of time loss, going back and forth to the patent office and arguing and amending things and all that. That was one idea I had. The other idea I have is that the patent office ought to have a situation where you go there on a given day for prosecution, and you go back and forth with the examiner there and then by the end of the day, decide what patentable subject matter you have, In other words, you amend your claims, he takes your patent, goes, does a search, gives it back to you. You're sitting in the patent office, you amend it again, and you argue him there and then, and at the end of the day, bang, your patent is granted to you, or you're told, nope, you can't get a patent without X, Y, Z. That was just an idea of mine to rapidly finish prosecution while everybody is focused on that particular invention, Not sure if you guys agree with that.
Yeah, it'd be a very interesting way to do it, for sure. I think the aspect that you mentioned with regards to being able to conduct the search and making sure that it's actually novel is the only aspect that I think would be a hurdle at that point, but I don't see why not.
Right.
Craig, do you have any input for us? Anything that you'd like to see differently or improve?
I think briefly from my perspective, it's probably more geared towards the area that I practice in, but the law with respect to 101 patent eligibility, I think that should have been dealt with in, dealing with rejections on prior art, like 102, 103, and then 112, like enablement written description, rather than kind of folding all these things together into this convoluted analysis on 101. That's essentially my thought, but I think that might be too specific for the general audience we're talking to today.
Thank you very much, Craig. And I think we've gone over the time by a little bit. Final question for our panel. We'll start off with you, Craig. Any advice that you'd like to give for your peers and others that are with us today? Anything that you'd like to share?
Yeah, I mean, I think this advice goes for attorneys and others practicing in this space. It's just that the importance of communication, as I had said, when we have our dialogues about what the search scope is and back and forth, and when we interview all the cases, office actors, we want to talk to the examiner all the time. So I think it's important to have as much communication as you can, and I think oral communication is the kind of best way to get to the point of things, and avoid some issues of back and forth where you and the examiner or you and the searcher might be talking over each other's heads, where if you just had a quick call, you might get on the same page and get to the end result that's beneficial to the client in a much more efficient and better manner.
Thank you very much, Craig. Todd, would you like to leave us with any final advice or tips?
I think everything that's been shared today has been very helpful. I would agree with what Craig said. Getting into a direct communication with the examiner as early as possible to see where that person's mind is and trying to work together. I mean, at the end of the day, it's, you know, the examiners sometimes forget, and so do the attorneys, that prosecution is not really supposed to be an adversarial situation. It is supposed to be an opportunity to work together. And is it, was that, I'm assuming that's your battery, correct?
Yeah.
Okay. You know, I have always found that open line of communication in any circumstance will always benefit your cause. And it's the easiest way to cut to the chase. I think David mentioned it as well. But yeah, no, I thought this was a very useful discussion. I don't know if anybody in the attendees have any questions, but I don't really have much more to add. Thank you.
Thank you very much, Todd. And David, would you like to leave us with final remarks? Any advice?
Yes, I second what both Todd and Craig said about establishing lines of communication with the examiner early and maybe repeatedly if it permits that. But I think in the same vein, that is a good idea to do that with your searcher too. You know, when you give them a search, maybe see if you can talk to the guy doing the search and quickly honing him in on what you are really looking for. So that makes the search more efficacious and probably produces a better result in the end as well.
Thank you very much, David, for your insight. We have concluded our CLE for today. I think we've gone over the time by a little bit. First and foremost, I would like to thank our panel very, very dearly for joining us. Thank you so much for your time today. I hope it was as insightful to our audience as it was to me. Definitely a pleasure to talk to every single one of you. Thank you for joining us today.